Good afternoon. It's Deanna Shulman, of course, on behalf of the defendants in this matter. I want to begin my closing argument, Your Honor, by correcting what has been an extreme misrepresentation of the nature and substance of Mr. O'Berry's depositions in this case. We didn't hear a lot about those depositions at all during the 2 weeks we spent together, but we heard a lot about them in closing argument a few minutes ago. There are, in essence, as Mr. Major suggested, 2 depositions of Mr. O'Berry of relevance in the plaintiff's eyes to this proceeding. Both of those depositions, Your Honor, occurred in a case called Meister versus Rhode Island et al. It was pending. It was filed in 2007, as this case was as well, and it was pending until last year in the 11th Judicial Circuit. So both depositions to which Mr. Major referred occurred in a case that has since been fully litigated. And what Mr. Major told you in closing is that in the first deposition, the September 2009 deposition, Mr. O'Berry repeatedly testified that the footage he was being shown during the deposition was of Tajii. Mr. Meister then suggested that in November 2009, that when he was asked where the footage was from, he said, "Oh, well, that's from Pluto," correcting a prior lie, according to the plaintiffs. What the plaintiffs have failed to tell this court, Your Honor, is that in the September 2009 deposition, Mr. O'Berry was testifying about the Tajii 12 video. The video in evidence, Your Honor, as Exhibit 3. That is the video, Your Honor, that contains only Tajii footage. It is the footage of the capture of Meister's dolphins.
Which one is this, number 3?
This is Exhibit 3, Your Honor. At page...
Whose exhibit?
It is Exhibit 3 in this proceeding. Plaintiff's exhibit. Sorry.
It's entitled...
The Tajii 12. And the testimony with respect to that video begins in that Miami deposition on page 206. And it's very important, Your Honor, because when he is testifying about that video and characterizing its source as Tajii, Mr. O'Berry is testifying entirely truthfully. Because as the evidence in this proceeding has established, that Exhibit 3, that Tajii 12 video, contains no photo footage. It contains only video from Tajii and Mr. O'Berry's introduction and his closing. 2 months later, in November, Your Honor, again in the Miami case, Mr. O'Berry testifies about the substance of the video, but an entirely different video. In that deposition, Your Honor, he's being asked about the de medio a medio broadcast, which is, oh, you know what, I'm sorry, Your Honor, that's Exhibit 3. The Tajii 12 is Exhibit 5, my apologies. The de medio a medio broadcast is Plaintiff's Exhibit 3 in this proceeding. That is what Mr. O'Berry is being asked about in his November 2009 deposition. It is the first time and the only time he has ever been asked about the substance of that video, and he truthfully testifies as to its source. And when the photo footage comes up,
testifying about what video?
The de medio a medio broadcast,
okay,
which, as we established during the proceedings here, contains those 3 different sources. And I'll get into those more later. But the important point, and that, I'm sorry, in the November deposition, he begins to testify on page 165 of that transcript. But what the plaintiff has done a few minutes ago, Your Honor, is exactly what we have said from the beginning is in itself a fraud on this court. They have taken Mr. O'Berry's testimony about 2 entirely different videos, juxtaposed them to lead you to believe that Mr. O'Berry lied in the first instance and finally claimed clean in the second instance, when in fact, Your Honor, if you look at those depositions which the plaintiff put in evidence, it is entirely clear that Mr. O'Berry is testifying about 2 separate videos. And he testifies truthfully.
3 different sources.
Well, in these 2 depositions that they are juxtaposing and trying to tell you that the first time they lied about the source and the second time he came clean about the source, Mr. O'Berry is in fact testifying about 2 different videos. And so you cannot juxtapose that testimony and draw a conclusion that he lied the first time, because the first time he was asked about the only video that contains no photo footage. And I wanted to begin by clearing that up, Your Honor, because it's a very important misrepresentation of the evidence in this case. Now, during our first hearing 18 months ago, Your Honor, you provided to us 3 cases that describe and define the law of Florida regarding what amounts to a fraud on the court. We have, again, provided copies of those cases to you today, but these are, in fact, the citations you gave us 18 months ago. A fraud on the court, like any fraud, Your Honor, must be pled and proven with specificity. It must be articulated specifically, and it must be established by clear.
Don't ever have a cell phone in my car. Yours? I think I've done that with you before, haven't
I don't remember. Fraud must be established, Your Honor, by clear and convincing evidence. And as the cases that you provided to us 18 months ago, and we have in turn provided them back to you, explain, a fraud occurs in one of 2 instances. A fraud occurs if by clear and convincing evidence the plaintiff proves that the defendants concocted an unconscionable scheme to fraudulently interfere with Your Honor's ability to adjudicate this matter. For example, perhaps by juxtaposing deposition testimony about 2 different videos and holding it out as testimony about one. Or, Your Honor, a fraud can occur.
Let me have the attorneys at the first meeting. Have an attorney here. Off the record. Off the record. All right, so you just finished telling me how you separate from the testimony about the Tajii 12 film. Highly truthful. Please proceed.
And right before we broke, I was explaining to you, or reminding the court of the 2 ways to commit a fraud. The second being that the defendants embarked upon an unconscionable scheme to fraudulently prevent the plaintiff from presenting its side of the case. Now, we spent 2 weeks, Your Honor, in this evidentiary hearing, and we've heard a lot about whether captivity is good or bad, whether we should just leave Japan alone because a small portion of it has captured dolphins for hundreds of years, and other matters, as Your Honor and I have repeatedly questioned throughout the proceedings, are not really relevant to the issues of fraud before this court. Mr. Penalta described during his 5-hour opening statement that Earth Island and O'Berry were defrauding the world, and that there was some sort of extortion plot going on. Mr. Penalta told you during that opening that his terrorism expert would describe for you the modus operandi for bringing about this fraud. That expert, of course, Your Honor knows, did not testify. Mr. Penalta also told you how Mr. Meister would connect the fraud for you, and then the plaintiff did not call him as a witness or ask him a single question on cross-examination. The reason, Your Honor, is simple. This case is not about whether dolphins are good or bad. It is about whether my clients committed a fraud on the court. The unsubstantiated arguments, whether captivity of dolphins is good or bad, or whether, frankly, dolphins are good or bad for society. But the unsubstantiated arguments made by Mr. Penalta during that lengthy opening statement was never demonstrated by any evidence. The plaintiff put on most of its case, as you know, through Mr. Turner. He testified at length about captivity of dolphins. He testified that his expertise is in the care and treatment of dolphins. He testified at length about the Tajii drive harvest, even though he never has once witnessed one. He testified, without any first-hand knowledge, that the drives in Tajii are humane and proper. We know from Mr. O'Berry, who has witnessed them, and has been there many times, and even videotaped one, that he believes them to be inhumane and cruel. It's not difficult to understand Mr. O'Berry's perspective in this controversy, but it has nothing to do with the fraud on this court. Why, Your Honor, as I have asked repeatedly throughout these proceedings, have we invested so much time, party, and judicial resources on these extraneous matters, in chasing waterfalls that have nothing to do with the fraud? The answer is simple, Your Honor. There is no fraud to focus on. We didn't focus in these 2 weeks on anything Mr. Major told you in the last 30 minutes. If we had, it would have been a very short proceeding. There is no fraud, Your Honor, not even close. Your Honor, we went about this course of litigating the issue of whether captures of dolphins is correct or good for society for weeks on end until the very last day of this hearing when Mr. Canalta took the stand himself to try to establish that which Your Honor could glean from reading the discovery responses. Frankly, it was a little awkward, Your Honor, as you can imagine, having been the subject of the disqualification motion just 2 weeks prior, that the plaintiff's counsel took the stand in support of this fraud. According to Mr. Canalta's testimony, the fraud occurred in discovery responses, in producing all the videos that you watched during the evidentiary hearing. Let's talk about those videos, Your Honor. The De Medio show, Your Honor, as Rick testified, is the show in which he gave an interview. He also gave some background materials to the De Medio show, and he gave them an interview. As he testified, he did not control what images were shown at any given time, nor could he see what images were being displayed on the monitors in the interview room that the plaintiff alleges were present. In fact, the plaintiff's own witness, Tanya Padilla, testified, despite having testified contrarily in her deposition a few weeks before, that whatever she could see on the video monitors during her interview on De Medio was not what was being shown on TV at the time. So even if Mr. O'Berry had seen the monitors during his interview, which he testified he did not, the plaintiff's own witness establishes that it was not what was being shown. So O'Berry, during De Medio, had no opportunity to comment directly on the images chosen by the producers of the show. Mr. O'Berry and Mr. Turner's testimony established that the De Medio broadcast contains 3 video sources. And this is important to the discovery in this case, Your Honor. The first,
Say it again.
the De Medio interview included 3 video sources. Mr. Turner and Mr. O'Berry both established the 3 video sources used by De Medio. The first source of video, Your Honor, is the ABC primetime piece. It is Plaintiff's Exhibit 2. The testimony established that it was produced by ABC sometime in 2005 or 2006. And it is about dolphins. We watched it, Your Honor. It is about dolphins all over the world, including Tajii. Mr. O'Berry gave an interview to ABC that was incorporated into that piece before he was employed by Earth Island. As he testified, he didn't edit it, nor did he direct ABC as to what footage to use.
And you said there were 3 sources to the Medio.
That's correct, Your Honor. The ABC Primetime Exhibit 2 was the first source.
2?
It's Plaintiff's Exhibit 2, correct. The second source of video for De Medio, Your Honor, is the 2004 One Voice video. It is Plaintiff's Exhibit 6. This video was produced in 2004 by One Voice when Mr. O'Berry worked for that company, which he testified is not related to Earth Island Institute. This video is about the Tajii drive harvest, and as is made explicit in the video, it also contains footage from other areas of Japan, specifically Futo. We watched the video, Your Honor, and at 22 minutes and 55 seconds, Mr. O'Berry, as the narrator, says this, quote, "Unfortunately, the whalers were successful in blocking One Voice from photographing the grisly scenes, but we obtained documentation of an earlier capture in Japan, and here is some of that footage." This video, one of the sources for De Medio, is explicit in its contents. If De Medio chose to use the video, either without watching it, or because it's in English, without understanding it, or without clarifying for its audience that the images it chose for De Medio were from areas other than Tajii, Mr. O'Berry did not cause this, nor could he have corrected it. The third source of video included in the De Medio interview of Mr. O'Berry is the Tajii 12 video, Your Honor. That is Exhibit 5. Mr. Turner and Mr. O'Berry testimony both established this is the Tajii 12 video, Your Honor, Plaintiff's Exhibit 5. Mr. Turner and Mr. O'Berry's testimony both established that this video contains no Futo footage. The video itself says the capture drive depicted was shot in Tajii in October, on the 28th specifically, of 2006. This is the one video that is about Ocean World's attempt to import the dolphins, and it does not contain a single image from Futo, Japan.
This was entitled what?
The Tajii 12, Your Honor. Exhibit 5. When Mr. Turner testified in his direct examination by plaintiff's counsel about this video, plaintiff's counsel showed it to you without sound. Why? Because the evidence would show that when you were able to watch it with sound, that this is the video that includes the capture of some of Ocean World's dolphins. It is the absolute documentation that Mr. O'Berry refers to during his de medio interview and during his meeting with Mr. Pewitt. The plaintiff showed you this video without sound, Your Honor, because they didn't want you to know that this is the capture footage of the plaintiff's dolphins. Instead, they told you, through their expert, Mr. Turner, that we had no video of the capture. And they did that, Your Honor, by lying to this court. Mr. Turner tried to establish that this video that you were then watching without sound could not be the Tajii 12. Yes, the Tajii 12 video. But it could not be video of the Tajii 12 because none of the Tajii 12, according to Mr. Turner's testimony, were captured on the date described in the video. Mr. Turner gave this testimony by relying on a document containing capture dates of Ocean World's dolphins known by Ocean World, Mr. Meister, and its counsel to inaccurately identify the capture dates. So this remarkable exchange occurs during Mr. Turner's direct examination, page 522, lines 20 through page 523, line 5 of the transcript of these proceedings. Question of Mr. Turner. And is there anywhere there that says dolphins were captured on October 28, 2006, based on your review of the records? Answer. There is no date that suggests any of these were collected on October 28th. But 5 of the dolphins were collected on that date, Your Honor. Plaintiff and its counsel knew that. They did not correct their expert witness. They let him testify untruthfully. And they didn't call Ocean World to tell you that the expert had either been given false information or had testified falsely based.
How do I know that? It's always shown to me that contradicts that affirms me.
Sure. When questioned, we called Mr. Meister to the stand, if you'll recall, Your Honor, and when questioned, he admitted that the dates provided to his expert or relied upon by his expert were wrong. We put in evidence, Your Honor, Exhibits 11 and 12, which provide the true capture dates of the dolphins.
This is Defendants 11.
This is Defendants 11 and 12. And in fact, Your Honor, through the testimony of Mr. Meister, who we called as a witness, and those 2 exhibits, we established that 5 of the dolphins were captured on the date described in the Tajii 12 video. 4 more were caught, Your Honor, as the evidence established through Mr. O'Berry's testimony and the photographs that he took while he was there. Exhibits 11 and 12 also established that 4 additional dolphins were captured on October 26th. Mr. O'Berry testified, and we showed some photographs, that he was in Tajii observing the drives on that date. So in the end, Your Honor, Mr. O'Berry witnessed the capture of 9 of the plaintiff's 12 dolphins and prepared the Tajii 12 video, which under directed or cross-examination of Mr. Meister by the defense was admitted to have occurred on exactly the date described in the Tajii 12 video. But the plaintiff led you to believe that Mr. O'Berry did not observe the capture of these dolphins by allowing its expert to testify based on false information. Your Honor, that sounds a lot to me like setting out to fraudulently interfere with your ability to adjudicate this case by having its expert rely on documents plaintiffs and its counsel knew to be false. The video that describes the capture contains nothing other than video from Tajii and Mr. O'Berry's introduction. This video, this absolute documentation, shot on October 28th, the day our exhibits established 5 of Mr. O'Berry's dolphins were captured, contains no footage from Futo. Now, at heart, Your Honor, what Mr. O'Berry told de medio or Minister Pewitt is irrelevant to the posture of this fraud proceeding, What matters here is how O'Berry and Earth Island conducted themselves in this proceeding as between Your Honor and its opposing side. Perhaps realizing this, though well after the parties in the court had sat through lengthy testimony on irrelevant matters, the plaintiff put its own counsel on the stand. Mr. Penalta testified largely to matters to which the parties had stipulated the court could take judicial notice. Clearly, the significance of Mr. Penalta's testimony was not in reading things that Your Honor could read for himself. It was in attempting to establish that these documents do not say what they clearly say. Let's start with the answers, Your Honor. Mr. Major in his closing talked about the allegations of the complaint and how we framed our answers in response to the allegations of the complaint. The allegations of the complaint do not allege that the supplying the video to Demetrio Medio is the basis for this cause of action. It is much broader and less specific than that. Mr. Penalta testified that defendants committed a fraud by asserting truth as a defense. Mr. Major tried to characterize these defenses by saying that O'Berry said that everything about the plaintiff was true. The actual defenses, when Mr. Penalta read them into evidence, read very differently. We asserted that the statements made by O'Berry about the plaintiff were true or reasonably believed to be true, that they were substantially true, and that Mr. O'Berry was privileged or justified in making statements. These are common defenses, Your Honor, to attempts to silence free speech. The assertion of a defense is not the presentation of evidence. It may, in fact, turn out to cover some, all, or none of the claim, but the mere assertion of a defense simply cannot be a fraud. We move then to the discovery responses, Your Honor, and Mr. Major spent a lot of time on that in closing and very little time on that in the actual trial, perhaps realizing that no fraud had been discovered. I'm sorry.
This is the actual trial.
Evidentiary hearing.
Oh, you thought you were referring to me. Was that a trial that I made?
No, Your Honor. It never reached trial. Perhaps realizing it had not established any fraud, Mr. Penalta testified falsely about the substance of defendants' responses to production. We read them, Your Honor, during the last hearing. They focused a lot on the first request for production, number 3 to Mr. O'Berry, which was copied and served as number 2 to Earth Island. This is the first set of requests for production, the second request to Earth Island. Photographs, films, CDs, and or videotapes in the possession, custody, or control of the plaintiff, his agents, servants, or attorneys, regarding the subject matter of plaintiff's complaint, including but not limited to television programs in the Dominican Republic and other countries, film festivals, and other outlets of the plaintiff, and the contracts or business relationships which are the subject matter. During the direct examination of Mr. Penalta, Mr. Major tried to define the term subject matter of the plaintiff's complaint. But if you look at the request for production as we did back then, there is no such definition. Mr. O'Berry limited his response to documents concerning the plaintiff or the Tajii 12. Earth Island, the party that produced these videos, did not limit its response in that way. And in fact, all 3 of these videos, Your Honor, which are sources for included in the Demetrio Medio interview, that is at the heart of this case, are directly responsive to this request. Give us everything you have about television programs in the Dominican Republic. Each and every one of those videos is included in part in the Demetrio Medio interview. It is entirely responsive. Had we not produced them, Your Honor, we would have been properly the subject of a motion to compel. Having produced them, we are subject to a fraud motion. That isn't going to work, Your Honor, because you looked at number 2 and you yourself said this is a very broad request, seeming to understand why we would produce these videos in response. So the plaintiff and Mr. Major and Mr. Penalta as the witness go on to subsequent requests. And again, they misread the request. The requests say we have already produced these documents in discovery. Mr. Penalta testifies, well, they gave me these videos again. And never once can he identify when or where or how, but he knows we gave them to him again, despite the fact that when you read our actual responses to subsequent requests, we never categorize, we never do anything other than say, everything we have has already been produced to you. And if you'll remember from Defendants Exhibit 8, in May of 2008, We send that letter.
Which one's that?
Defendant's Exhibit 8 is the transmittal letter, in which we transmit each and every one of the videos that has become the heart of this fraud proceeding. And in May of 2008, we send a letter, we say, Dear Plaintiff's Counsel, here are 1 through 930 something for Earth Island, these, and 1 through 100 something for Mr. Berry. These are the documents responsive to your first, second, and third request for production. Not a single letter is in evidence, Your Honor, in which we ever said, this document is responsive to this request, and this document is responsive to this request. The rules of procedure, of course, allow us 2 options: produce as they're kept in the ordinary course, or categorize them. We chose the former. All of these things have been subject to motions to compel throughout these last 5 years. Those issues have been litigated with respect to deficiencies, but never once is there a shred of evidence that we produced any video in response to any specific request. So,
you've got a few more minutes because of my straight.
Okay, thank you, Your Honor. I appreciate it.
About 4 minutes.
Okay, thank you. So then Mr. Penalta begins to testify that we handed him things or mailed him things, because none of this is going to work because it's belied by the actual documents. He couldn't articulate any record of these transmittals. Instead, he said that we handed him these videos during a deposition, and that we told him, these are the videos responsive to all your requests for production. That too was a lie, Your Honor. The plaintiff didn't provide you any evidence or documentation that had occurred because it had never occurred. The exchange described by Mr. Penalta is documented. It has nothing to do with production of documents. In fact, it's nothing to do with this case. We've put into evidence today, Your Honor, by stipulation of the parties, Defendants Exhibit 14 and 15. Those 2 exhibits establish, Your Honor, that what Mr. Penalta was testifying, that to that moment where we handed him everything and said, this is responsive to all your discovery requests. It turns out, Your Honor, that what we did was we handed, during a Miami deposition, our exhibits for trial in that matter. The letter we submitted in evidence, which has been marked Exhibit 14, indicates that we will be providing copies of our exhibits to the plaintiff. On the record, during Mr. Meister's deposition at page 373 to 374, that's been entered as Exhibit 15. When Mr. Penalta states for the record that defendants have handed him a stack of evidence, we quickly correct him and say, no, Mr. Penalta, this is simply a copy of our exhibits for trial, consistent with Exhibit 14, the letter we sent a few days prior. That exchange had nothing to do with discovery in this case, and in fact, nothing to do with this case at all. Your Honor, the plaintiff establishes its fraud by juxtaposing deposition testimony in a manner that mischaracterizes for you what actually occurred, by misreading and rewriting discovery requests and responses to suit their need, when those answers are belied by the documents themselves. The plaintiffs have committed a fraud on this court, Your Honor. 18 months ago, I asked you, at the conclusion of this, please spare my client the burden and the expense that it has had to endure for over 2 years, chasing router calls, going down rabbit holes, and whatever other, I know Your Honor doesn't, it made a joke earlier, but going through this basic sideshow, Your Honor, I would ask that not only you deny the motion for fraud in the court, Your Honor, but that you award, consistent with our request many months ago, my clients their fees and expenses in litigating and defending against these baseless fraud accusations.